In today's story, we look at the Fifth Circuit's reasoning as to why OSHA's COVID mandate on employers is not legal. Stick around and I'll give you my color of law. Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you enjoy this legal education content, please remember to subscribe. It helps our channel grow. For today's case, we're looking at the recently expanded decision from the Fifth Circuit Court of Appeals that analyzes the Biden OSHA mandate. As I'm sure many of you are aware, the Occupational Safety and Health Administration, a federal government agency that looks at workplace safety, has attempted to put in place a mandate that people that work at places with more than 100 workers are required to either take the vaccine or to mask up and test at least weekly. The Fifth Circuit Court of Appeals has presented an opinion in which this order is stayed and prevented from going into effect. So we're going to take a look at their reasoning and try to understand what's going on here. OSHA, which is a federal government agency that deals with workplace safety, has put in place what they're calling an emergency temporary standard that they themselves in June of 2020 of this same year determined was not necessary to protect working people from exposure to COVID, but now suddenly it is. In its 50-year history, OSHA has issued just 10 of these emergency standards, and of those, only one survived a court challenge. So not a great history when it comes to OSHA and the emergency standards and their ability for them to remain legally in place. Many of the petitioners in the Fifth Circuit case are covered private employers. So they're not government, they're just people who work at a business that's run by other people. Their standing sue, of course, is obvious. The mandate that's proposed imposes financial burdens upon the employers for failure to document, failure to get their employees vaccinated, and otherwise threatens the workplaces by forcing unwilling employees to either take their shots, take the tests, or hit the road. So there is a severe economic burden to both employers and employees from the OSHA-related standard. The Occupational Safety and Health Administration is created by Congress to ensure safe and healthy working conditions and to preserve human resources when it comes to the workplace. It was not, and likely could not be, under the Commerce Clause and non-delegation doctrines intended to authorize workplace safety administration in the deep recesses of federal bureaucracy by making sweeping pronouncements on matters of public health affecting every member of society in the profoundest of ways, namely when it comes to one's personal health. So here we see from the U.S. Fifth Circuit, we have two potential problems. One, non-delegation doctrine. There's Congress, only Congress can make laws. So while federal agencies have the ability to regulate, there comes a point when there is so much authority given to an agency, it becomes legislative power, and that becomes improper. And also, the ability of OSHA to do anything as a matter of federal law is a creature of the Commerce Clause, which has the ability of Congress to regulate interstate commerce. But this is touching traditionally state-level activities, namely the regulation of health, and so poses problems from a regulation standpoint of federal law by trying to squeeze this into Commerce Clause power. The Fifth Circuit notes that even if it does pass constitutional muster, the proposal and order is flawed for other reasons, in fact, on its own terms. The mandate strains prescriptions combined make it a rare pronouncement that's both over-inclusive by applying to employees in all industries and all workplaces with basically no attempt to differentiate among the industries or among the workers, and also under-inclusive by only going to employers with more than 100 people, which is kind of strange when you're talking about an apparent safety crisis that warrants some sort of immediate action. The Fifth Circuit notes that one of the reasons that the Biden administration may have chosen the OSHA route is because OSHA has a procedure for these kinds of emergency regulations. Most federal agencies have to go through a notice and comment period. That is, they have to put forward a non-final regulation, receive comments, and only after that can they promulgate a final regulation that has legal effect. However, OSHA has the authority to issue these emergency mandates that are effective immediately. So the Biden administration apparently simply lost its patience with the American people not getting vaccinated fast enough. And so they hit upon the OSHA mechanism because it allows for this fast, instantaneous action. But of course, it only allows that in cases of valid exercise of that power. In its argument noting why Texas believes this mandate is invalid, Texas makes the argument that the phrases in the statute, substances or agents, and toxic or physically harmful substances, are not similar enough to airborne viruses to be within the same scope of those terms. To avoid giving undue breadth to an act of Congress, courts rely on a principle that a word is known by the company it keeps. Here, OSHA's attempt to shoehorn the virus that is both widely present in society in general and therefore not limited to the particular for any kind of workplace or any kind of employee, and non-life, threatening to a vast majority of employees, into the neighboring phrase connotating toxicity and poisonous is yet another transparent stretch. Yeah, it's a little bit weird to squeeze a virus into the phrases toxic and poisonous. Most poisons have a tendency of basically killing everybody. Most toxins have a tendency of basically killing everybody. This is not really a toxin or a poison, not for the least of reasons that it's nature made, and even if that weren't an issue, its death rate certainly is not comparable to the vast majority of poisons and toxins. Equally problematic, however, is that it remains unclear that COVID-19, however tragic and devastating the pandemic has come, and one can draw their own conclusions on those issues from looking at relative numbers of other kinds of diseases, that this poses what the statute requires, a grave danger, which is the standard required for this kind of emergency regulation. OSHA itself has concluded that grave danger is not sufficient for a chemical that can cause cancer or kidney damage even at high levels of exposure. So if that's not a grave danger, one wonders why this might be. The mandate itself also concedes COVID-19 is not necessarily a grave danger because it concedes, as anyone knows, that COVID-19 symptoms can go anywhere from the non-existent to the mild to the critical. The Fifth Circuit also notes that the regulation makes no attempt to explain why OSHA and the president themselves were against vaccine mandates before they were for one here. So why have things changed in the interim? What facts have changed is not specified in the order. Even though agencies enjoy a wide latitude of changing their regulations, even in ways that are contradictory with prior regulations, as cases like Our and Brand X, cases I've talked about on this channel before, to some annoyance, note, even though they do have this power to change, they cannot do so in an arbitrary and capricious way. So when they do so sub silentio, that is, in the face of silence, when they don't provide reasoning and a detailed explanation, this suggests an arbitrary and capriciousness, particularly where the prior policy has caused a serious reliance interest. So while agencies can change the rules, they can't do so willy-nilly, nor can they do so without detailed reasoning to show why the new reasoning makes sense, which was not done in this regulation. The Fifth Circuit goes on to note the necessity of the mandate. The mandate, they note, is staggeringly overbroad. Applying to 70% of private sector employees at a minimum, in workplaces that are diverse as the country itself, the mandate fails to consider what is perhaps the most salient fact. The ongoing threat of COVID is more dangerous to some employees than to other employees, yet the mandate itself is universal. All else being equal, the court notes, a 28-year-old trucker who spends their workday in the solitude of their trucker cab is probably much less vulnerable to COVID than a 62-year-old prison janitor who spends a lot of time around people. Also, the Fifth Circuit notes that the mandate is also under-inclusive for a reason I've noted before. Why 100 employees? Why 100 employees or more? It doesn't really make sense. Now, OSHA has said this is for administrative convenience because large employers will be better able to administer the rules. And the court notes that this may be true, but this kind of thinking belies the premise that this is an emergency due to safety. If this were truly a safety emergency, why would we say, but it's hard for employers under 100 employees to implement though? You wouldn't do that. It doesn't make any sense. So therefore, this under-inclusiveness is a telltale. The government interest is not really a compelling interest, not really a grave danger, but really is merely a pretext for liberty restraint through other means. You can't say this is a grave threat that requires emergency action because all workers' health are at threat, but only if there's 100 or more. 99 or less, totally okay, doesn't quite make sense. Of course, we would be slightly remiss if we didn't point out that there are, in fact, grave constitutional concerns. So the statutory concerns are not the mere problem. The mere defects of the instrument are not the problem. There are constitutional concerns. Most notably, that this vaccine requirement falls squarely within what's traditionally called state police power, the general power to do stuff. State level can mandate vaccines. That's at least what Jacobson stands for, which is a case that, while controversial, does remain good law. The federal government doing this is stepping on traditional state authority without a clear mandate from Congress, and even if there were a clear mandate from Congress, you would raise clear constitutional concerns, at least, because of interests that are inherent in the federalism structure of the United States. The Fifth Circuit also notes it's quite interesting to note that OSHA's logic would imply that Congress has given an Occupational Safety Administration the ability to make health policy for the public at large, which is pretty strange because Congress has health-based organizations such as the National Institute of Health, such as the Department of Health and Human Services, such as the CDC. So why would they give OSHA, which is within the Department of Labor, not within the Department of Health, the ability to regulate health generally? It doesn't make any sense. So in doing this, OSHA runs afoul of the very same statute where it appears to try to draw power from and violate the structure of Congress's own pronouncements. Thus, that brings us to the end of this case, so let me give you my color of law. I rate this case as blue, reasoned. It is a well-reasoned opinion that pokes obvious holes at the mandate from the OSHA administration. OSHA is simply trying to do far too much for its authority. The very nature of the mandate that they're proposing by putting vaccines in the human body is a nature that goes directly to people's health and bodily autonomy, which really can't be said for any other regulation. These kinds of authorities, to the extent they do exist, either exist at the state level or exist within agencies of the Department of Health and Human Services, such as the NIH or CDC. Congress did not grant OSHA broad authority to regulate the health at large, and their own regulations belie their own premise. By leaving it to only 100 employees or more, they show that this is not truly a health threat, but merely a subterfuge to try to find an excuse. So this opinion seems well-reasoned, solid, and the OSHA mandate, for the moment at least, is held up, and then brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.